SJC-13010, Mederi, Inc., the City of Salem.
Okay, Mr. Sheehan, good morning.
Good morning. May it please the court. William Sheehan from Mederi, Inc. And first, I'd like to thank the court for the opportunity to appear personally here today.
Welcome.
It was 40 years ago that I first appeared before this court, and it's always an honor and a privilege. Mederi seeks a license under Chapter 94G for the retail sale of recreational marijuana to adults. It obtained a special permit as required by Salem zoning, and then applied for and was willing to execute a host community agreement, sometimes referred to as an HCA. The City of Salem refused that HCA, preventing Mederi from getting to the next step in this two-step process. What we have is a two-step process created under Sections 3 and 4 of Chapter 94G. In order to advance to the CCC, Cannabis Control Commission, one must have an executed host community agreement. Mederi challenged that refusal.
Counsel, I hate to interrupt you, but I'd like to just kind of drill down right to the issue here. We know 94G reserves to the local community control over who gets to operate these retail establishments. And that's partially embodied by having the requirement of the host community agreements. If we read it the way you read it, isn't it just a matter of who gets there first? Then the local community is obligated to enter into a host community agreement just by virtue of the fact that you already got the permit for under the statute, and now you get to go back and say, I beat the other guy, so you have to engage with me.
With all due respect, it's not that simple, and it's not that the city has no control over the who. The city has a great deal of control. I'm going to talk about the city control under Section 3, but Section 4A, Roman numeral 10, talks about who is to determine to whom licenses will be awarded. And it's not the city, it's not the municipality, it is the CCC.
It is, but you still have to be armed with a host community agreement.
You have to
And if the city has determined that you haven't met their requirements and they don't want to engage with you and somebody else, what are we supposed to say? That because you've gotten the initial permitting from the CCC and now you come back and say, now we want to do the host community agreement, but they say no for a variety of reasons, and they've said that in their denial. What are we to make of the fact that you're saying that they have no local control to say, we don't want to pick you, but we want to pick them?
And I'm not suggesting there is no local control. In fact, there are 3 layers of local control, and that local control is carefully spelled out in Section 3. The first layer is in the citizenry of a municipality. Marijuana is to be lawful in a municipality unless the citizenry by vote rejects it. The second level of local control is vested in the legislative branch, because Section 3D talks specifically about a city being able to control by ordinance, not in any other way, but by ordinance, time, place, manner, and number, which the city did. In fact, if you, as the City of Salem did, if you elect to pass an ordinance that's in the nature of a zoning ordinance, you can require a special permit. So there's actually a third level there of protection, and that is afforded by the special permit granting authority, also done here. Then there is a fourth level of control, and that's a control in the executive branch. In this case, it would be the mayor. The mayor is allowed to dictate the terms of, set the terms of a host community agreement. But setting the terms of that, the conditions, is different from selecting who it is who will be awarded the license. Because if you allow the mayor or any chief executive officer to issue the license, determine who issues the license, you've adopted the Chapter 138 model, which—
Can I ask you, Counsel, when it was helpful as you described the process, that last bit where the mayor determines whether or not to enter into an HCA, is that discretionary?
No, whether the terms, the conditions that are to go into the HCA absolutely discretionary with the mayor.
So given
However-
that the terms are discretionary with the mayor, how can we, per your count one, have a order for a mandamus to require the mayor to enter into an HCA?
Because the obligation to execute an HCA with someone who has applied for it and has, in this case, obtained a special permit, the obligation to sign an HCA is not discretionary. The obligation to sign is mandatory.
But that doesn't make sense. If the conditions of the HCA, the terms of the HCA are discretionary with the mayor, how can we, as the judicial branch, order the mayor to enter into the HCA as to which the terms to which are discretionary? That seems not logical to me.
Well, I would suggest respectfully that there is a logic to it. The logic is that the city, through that third layer of protection, we've talked about the citizenry, we've talked about the legislative protection, we've talked now about the executive. The executive branch gets to set, as it did in this case, it set 21 conditions when you take a look at the application process. Those conditions were set, those conditions can be determined by the mayor. Now, we have an HCA, the conditions have been set. Can the mayor refuse to sign that HCA with any particular retailer? The answer to that question has to be no,
So
because
are you saying then that anybody who agrees to the HCA should get the HCA, let it all go to the Cannabis Control Commission, and then they'll decide who gets the slots?
that's exactly the way this process is designed. And that is, in this case, there was a barrier, if you will, to receiving an HCA. That is, a special permit had to be obtained. But Mederi crossed that barrier and obtained the special permit. The next thing that has to happen here, when you're looking at it from the retailer's point of view, is, are you willing to accept the conditions of operation, not selection, but the operations, the conditions of operation that the city, in its discretion, has decided to set? There may be conditions that a certain retailer would say, I'm going to take my potential license and go elsewhere. I'm not going to live with those conditions. Those conditions, we're not challenging the city's ability to set them.
Council,
Well-
can I ask you then to address the difference between this statutory scheme and the gaming scheme that's pointed out by the commission here in their amici brief?
Yes, the
Because it seems like based on their summary of the gaming rules, the Gaming Commission does have the authority to require the execution of the local community agreements in that scheme. Whereas here, it seems under 94G, there is no authority for the commission to require the local community to enter into the HCA.
with respect to host community agreements under both 94G and the gaming statute, the language is identical. Execution. The only time you get into negotiation, the only time you'll find that word in the statute, in the gaming statute, does not apply to host community agreements. It applies to so-called memoranda of understanding with neighboring communities. We have nothing like that in Chapter 94G. That analysis is helpful because it does draw a distinction between execution and negotiation.
But then
I
don't
would
get-
agree that if
doesn't
what we were
make it-
talking about,
I don't get that. I mean, how can, if they can set terms and conditions and say you don't meet those terms and conditions, I mean, they may be acting improperly, but don't they get to set terms and conditions and decide whether you meet them? If they can't do that, then I don't know what they're doing. And then you've also got to combine the fact with Justice George's question, which is, this is decided on sort of a rolling basis. So it would be just a race to the CCC because they don't look at them together. So it just seems obvious to me that they can set terms and conditions and evaluate whether you met them. Now it gets tricky and potentially improper if they only send up, the number they want each time. That's a separate question, but I don't see how you can avoid that they set the terms and conditions. I just, how do you enter into agree? How do you force someone to agree to things that they say you don't meet?
The city sets the terms under which a retailer will operate.
And they
However,
said you didn't meet them. They say you don't meet them here. They say
No.
you're, go ahead. Mhm.
I apologize. The city hasn't said that we don't meet the conditions. The city has said we don't measure up in comparison to other applicants.
Well,
Very
let's talk
different.
about that for a moment, Mr. Sheehan, and I'll agree with you. If you look at section 410 about the CCC determining which applicants shall be awarded such a license, that's not a clear answer to our question. So what we have here is a limited amount of host community agreements. And then we have the CCC is going to decide who gets a license. So if you have more applicants than you have spots for, who should decide which applicants are going to be able to be in Salem? Should it be the entity that understands Highland Avenue and can appreciate which 2 out of 6 would be better, who understands Dodge Street and is able to take into account what the implications of choosing this applicant from that applicant should be? Or should it be a governmental agency in Worcester?
One way, the best way to preface my answer to your question is the importance of economic empowerment, the importance of social equity. It is replete in chapter 94G. When you look at chapter 55, section 56 of chapter 55, which amended the initiative petition legislation, there's a specific reference in there to what are we trying to do here? We're trying to help the disadvantaged.
That's a great
Historically.
point, Mr. Sheehan. I'm going to just, I don't want you to finish it. It's a great point, but have in mind while you're answering the question that the amici agree with you, but they say, but the statute says what it says. We need an amendment to recognize that problem. It's a very important and good point, but the CCC recognizes they can only interpret the statute in one way.
But why would you interpret the statute? Our interpretation of the statute gives voice to that unquestioned goal. The city's interpretation does not. It is basic in any interpretation of a statute that you must interpret it in accordance with what's trying to be accomplished. But now let me answer your question.
But first you have to look at the plain meaning of the words of the statute. Can you start there?
Sure, I thought that I did, but I'll do it again. 4A, Roman numeral 10, it is the CCC who shall determine who gets the license. But to answer Justice Lowy's question, there is certainly local nuances that are involved here, but those local nuances are not dealt with at the executive level. They're dealt with at the legislative level by way of the zoning ordinance, and in this case, by way of special permit. The special permit granting authority, when you take a look at section 9.4 of the zoning ordinance, it specifically says that among the considerations of the ZBA will be effect on neighborhood, effect on community. So all of those considerations that you are rightly concerned with are taken care of.
But 7 end up, or 8 end up meeting them. 7 or 8
Right.
end up meeting them. And
Sure.
if they do, the idiosyncrasies of that particular municipality that's going to have 5 host community agreements is not going to be made by the mayor of that municipality.
Once the zoning board has determined that all of those locations are appropriate, which it has, it's not for the mayor to say, no, they aren't. And to address the question at the CCC level, the suggestion that all the CCC is doing is sort of rubber stamping whoever comes in first, that's not fair to the CCC. They are handling matters on a rolling basis, but they have to be qualified.
But
Chapter
then-
94.
can I ask how that works though then? Because that's where it gets complicated to me. So if they're doing it on a rolling basis, they can't compare the proposals, right? At all. They're just gonna do an up or down vote on each one, right? Is that right?
That is right, and that has always been contemplated since 2016. That is that the distinction is between those who are qualified and those who are not qualified, not trying to grade by way of AA minus B plus
But
within that.
what if there are 30 that are qualified and the city is only going to allow 5? It means that the first 5 who are qualified are going to get approved, right?
It does, and that's consistent with the whole concept of trying to get in the marketplace legalized marijuana retailers. There was an encouragement by the CCC. It makes sense that
But
their
then-
regulation.
So it doesn't matter that the municipalities decided that some of these serve the city's purposes much better than others. I mean, I understand your point, and I agree with your point that the economic empowerment issue has to be dealt with. I can't tell is it at both levels or only one level? I assume the CCC could just reject every single one of these because Salem didn't take into account economic empowerment, could they?
Well, the CCC is designed to look at and required to look at the qualifications. I'm not so sure that it's not designed to look at what the city's selection process was.
But isn't that the problem? Won't you then have the chance of ending up with 3 of them that have been approved in the same block where the city would have preferred to have them spread out?
But the place concept, Your Honor, was determined, keep in mind that place, and that's your question about place, that's determined not at the executive branch under Section 3D. That's set at the legislative branch. That is by zoning ordinance. And the city of Salem, not the mayor, but the city of Salem, acting by and through its ZBA, determined that there would be no problem if there were 3 that were located close to one another. We know that that is so because our application was last. It's not true, as Judge Karp said below, that our application for a ZBA relief was viewed in a vacuum, not viewed in a vacuum at all. It was determined at the appropriate level under Section 3D as to place, and we've satisfied that. And if you allow the mayor to make the final call and not allow Mederi and others to advance, where under Section 4A10, the CCC would make its determination, all you have adopted, maybe not intentionally, but you've adopted the Chapter 138 local licensing board formula, that model, substituting the mayor for the licensing board, and that is the antithesis of what the initiative petition said and the antithesis of what the legislature said when it rewrote that.
Well, let's talk for a moment about the CCC's municipal guidance document. And I don't know about the antithesis, but there's at least a lack of clarity here. On the other hand, the municipal guidance document talks about the ability to have a cap on the HCAs. And you've got the special attorney general taking a position different than you in their amicus brief. You've got that CCA guidance, you've got Judge Karp's decision, you've got Judge Feely's decision. In a nutshell, Mr. Sheehan, why are they all wrong? Just can you give me a cogent reason why, well, they're all wrong?
The CCC, when it says, and I agree that it's puzzling, its reaction is puzzling, its misapprehension of its power is puzzling, especially when it says, right in its brief, there are 2 abuses that we're concerned about, and our interpretation of the statute doesn't cure either one of them. That's, I don't know what else to say, but that it's puzzling. As to Judge Karp and as to Judge Feely.
On that point, before you leave that point, couldn't they be wrong? They have the right to reject every single proposal if they're not happy with the economic empowerment. Right? They could just say, I've seen what the process produced, and it didn't respect the legislative, requirement of economic empowerment. And it could say that this 4% is in violation of the 3%. Couldn't they just do that and reject every single one of them?
I would say, no, it can't, because
Why
the
not?
regulation, the CCC's regulations talk of looking to the qualifications. There is a priority for economic empowerment applicants.
So if it didn't prioritize them, wouldn't it be in violation of this? I mean, I'm actually as bewildered as you that the CCC doesn't think it can enforce its economic empowerment priority. And it can tell the meaning of whether this 4% is consistent with the 3% language that in the statute. To me, those seem like what the CCC is best capable of doing. They're not good at figuring out, as Justice Lowy says, which is the best thing for Salem on Highland Avenue and those other things, but they seem to be able to do the two things that the statute prioritizes, can't they?
The terms of the HCA, not suggesting, and the statute certainly doesn't suggest, that the CCC has any role to play in the content of the HCA. And to try to get back to try to answer both of those questions.
No, but you haven't answered I'm trying to me, the statute seems to make sense in the sense that it's like federalism. It has a local regulatory review, and then it has this overview to ensure that these fundamental things appear in the fundamental statutory goals, economic empowerment, and don't let the municipalities, take more than 3%. It seems like that is consistent with this two-part review, a zoning and a local level review followed by this ultimate overview by the CCC. I don't know why they have to do it on a rolling basis. Is that in the statute that they have to do them first come, first serve?
Rolling basis is not in the statute, that's by regulation.
So they've crippled themselves.
It sounds to me as though the two of us agree on the twofold process. The question really then becomes, can the city prevent an applicant for 94G license by denying that applicant an HCA? And if it can, all we have is the local deciding to whom, in fact, the licenses will be issued. To answer your question, Justice Lowy, as to why do I think Judge Karp and Judge Feely, where do I think they went wrong, I guess is the question. They went wrong, in my view, by failing to appreciate what the CCC is going to do when it gets that application before it. It is not going to rubber stamp it. It is not simply going to say, oh, you've got an executed HCA, check mark, good enough, here's your license. And in fact, it doesn't work that way at all. The CCC, the application process, the package that's submitted, that has to be submitted to the CCC, hundreds of pages long, covering all kinds of elements that are associated with this industry. And the applicant must qualify on a whole series of issues, one of which, interestingly enough, is its capital resources, which is really what the city was concerned about. So it says, we want the strongest operators. That's what the mayor said in her denial letter to Mederi. But again, 180 degrees opposite of this whole notion of economic empowerment and helping the disadvantaged. So I think that where Judge Karp and Judge Feely went wrong was failing to truly appreciate the significance of what the CCC does.
Okay, does anyone have any further questions?
Thank you very much.
Thank you so much. Okay, Ms. Caldwell.
Good morning, Chief Justice Budd, and may it please the court. My name is Victoria Caldwell, and I'm here today representing the city of Salem and Mayor Kimberly Driscoll. Today, we are here asking the court uphold the decision of both Superior Court judges, which found that the city had the authority to determine which marijuana retailers it wish to enter into HCA's with, in particular in the narrow instance of where the city has legally adopted a cap on the number of retailers that may be cited within the city.
Counsel, let me follow up on just that one point because counsel just sat down answering that question. Because there is a cap and because by regulation, the CCC ultimately determines who gets these licenses on a rolling basis. So there really is going to be some advantage to getting in early or getting in first. Assuming that there's just the 5, why can't they just get in that bat?
I'm sorry,
And have the ACA be executed, and then it goes to the CCC, and then they determine who's the most qualified and appropriate applicant to get the license.
Well, Your Honor, from the beginning, we put out a process and said that we would be looking at retailers that had either had site control or had a special permit, and then we would enter into the HCA process with those folks who applied for an HCA. So we upfront told the applicants, and not in the record, but there was an avalanche of interest in locating in Salem. We were early to adopt our zoning regulations and pursue the siting of these operations. But right away, we told everyone that it would be we put out an FAQ on our website and said, hey, the city's going to look at those who come forward, and we're going to make decisions via the HCA process so that we don't have a first come, first serve. Otherwise, we would have just had a land rush to the zoning board, and the first people in and the first people out were going to be the first in at the CCC.
But Mederi met those threshold qualifications, didn't they?
They met the threshold qualifications. They applied for the HCA. They agreed to the terms and the process that we put out there. With the rolling aspect of the CCC's review, it really would have been whoever had both zoning. Well, actually, you don't even need zoning, to be honest with you. You need site control and zoning appropriateness to get a provisional license with the CCC. You don't even actually need an actual zoning decision. You just need, that can come on the back end, actually, but you need that.
Sure, but while Mederi had all of those things in hand and kept asking for the HCA, you were doling out, or the city was, executing HCAs with other applicants. So the number 5 kept turning into 4, into 3, into 2. All the while, they were saying, we met all of the qualifications, all your requirements, all your criteria, and we're asking for an HCA, and all the while, they're not getting an opportunity.
I think that what Mederi was owed by the city was not an HCA, but the opportunity to compete for an HCA, and they got that. If going to the social equity issues that were raised in the earlier argument, if you take Mederi's position and you just give everyone an HCA who asked for one and has demonstrated site control or site appropriateness and put those forward, there would be no opportunity for social equity, economic empowerment applicants.
Well, nobody's suggesting, Ms. Caldwell, you ask for one and you make sure that you have basic minimal qualifications. And 4A10 of the statute says that the CCC shall determine which applicants shall be awarded licenses. If everything about HCA applicants is vetted at the local level, and then you take the 8, 10, 12 applicants and you say, okay, here's the 5 that are the best, and you send it to the CCC, what is the CC doing other than saying, okay, I guess it's these 5 then. I understand they can, as Justice Kafka said, send it back. But why isn't it the agency that is in charge of regulating the industry, the agency that should decide who actually ends up with the host community agreement?
I think that the agency does ultimately decide because we provide these HCAs, we give them the 1-page certification that they have an HCA so that they can proceed to licensure.
But they never get to consider the plaintiff, even though they qualify. They never have a chance. The regulatory agency never has a chance to consider the applicant who qualifies, and yet they are the ones under the statute who decides who gets a license.
Well, I believe that the law provides for that, Your Honor. I think that the local control aspects of this make it such that the cities and towns can implement zoning and they have the HCA process both. And through that HCA process, they can make those qualitative decisions about which retailers would best work in the landscape in our 8 square mile city and impact the neighbors in particular roadways, particularly Highland Avenue, best. And I think that is a decision that was left to localities and to the mayor, and it's consistent with what the scheme was when the DPH.
So what is left to the CCC? That's what I'm trying to, I get what you're doing. And I understand that you say you have the ability to limit, but what does the CCC get to do then? Because I'm just trying to understand the balance of does what here.
The CCC gets to review the application, and we had our HCA process, but it wasn't a full-blown review that the CCC does by any means.
Do they get to review? Do they get to review whether you properly did economic empowerment?
I'm sorry, say that again, Your Honor.
Do they get to review whether you did economic empowerment correctly?
Well, going to the statute with respect to economic empowerment applicants, it's not in the record, but we did have an interest from an economic empowerment applicant who was unable to get real estate, unable to secure real estate. So our process actually helped, in a sense, by gathering them to allow for an economic empowerment applicant to come into play, and we could work with that if we were to get one. Mederi was not an economic empowerment applicant, and we didn't end up having one in that batch of applicants.
Can they reject all of them because you don't have an economic empowerment? There won't be an economic empowerment marijuana retailer in Salem? Can the CCC just reject all 5 of them?
I think the CCC has their regulations require that there are 2 types of preferences that they give for licensing, and that's the economic empowerment applicant and the pre-existing medical dispensaries converting to retail use. And they alternate, the regulations speak to that, but not to anything else. So I assume, Justice Kafka, that they could say, hey, we've seen too many of these and we'd like to hold off before we approve of any more in Salem to see if we can get an economic empowerment applicant.
So can I ask, what is this? This case only deals with the first level. Has the CCC issued licenses? Is that in our?
Yeah, I think it's in the. I think it's in my brief. We have 3 operating retail marijuana stores right now, and we have 2 others that have provisional licenses that have not opened. So right now we are at our cap.
So the CCC approved 3 of these already, even though you've got this 4% provision in your agreement. So that's been approved by the CCC?
Correct, and they're operational, 3 of them.
And they did not require you, and they okayed 3 of them without addressing this economic empowerment issue.
Correct, Your Honor.
Okay. I just want to understand that. Okay. Mm-hmm.
What can I ask you a follow-up on that licensing fee or the whatever the fee is called? Well, how is it that Salem can do the 4%? I was confused by that.
Well,
and the pay-to-play aspects.
There are two aspects to the economic terms in the HCA. One is the impact fee, which is authorized by Chapter 94G that cannot exceed 3%. So that is included in there. And then we also asked for, as a part of our minimum terms, which we put out there from the beginning, that we wanted a 1% donation to a transit enhancement fund and a $25,000 donation to a Salem-based nonprofit of your choice. And everybody, the 8, including Mederi, that came forward to request an HCA through the process, agreed to those terms.
Well, of course they agreed to them because they wanted to open up their establishments. But I guess my question is, how is that consistent with the statutory cap?
The statutory cap is a cap on the impact fees, and the city and other cities and towns have long entered into community benefits agreements with.
So if I call the fee something else, the Justice Wendlandt Donation Fund, then that's okay?
If it's a donation and an impact and versus an impact, I think there is a distinction.
But isn't traffic the biggest impact? How is a traffic enhancement fee not covered by the 3% impact fee? Because traffic is the major impact, one of the major impacts of these funds.
The traffic enhancement fund was just not generally about traffic. It was about providing a shuttle service within the city limits to be able to stop at these retailers.
But isn't that so instead of, okay, I don't know. So that was not litigated anywhere, this issue.
No, it wasn't litigated anywhere. We didn't brief on the specifics of that issue.
It's concerning, isn't it? Because the CCC is not going to be able to see certain applicants. Maybe the city of Salem says, well, let's see how much you're willing to contribute mitigation of traffic on Washington Street. And so a number of applicants step up with that. And the CCC, that has the overall regulatory responsibility and authority, is never seeing HCA agreements from all these other well-qualified applicants because they might not have the deep pockets when the legislation is trying to protect people who might not have deep pockets who want agreements. I mean, not only is where's the fairness in that, where's the compliance with the statutory goals in that and limitations?
With all due respect, I think that the additional fees or additional donations are things that are paid once the operation is up and running. There aren't upfront fees that are a barrier to entry for any applicant. I think, as the CCC pointed out in its brief, that they have asked the legislature for a fix for this, and they have not received it, and that's where it stands.
They've asked for a fix on the economic empowerment, right? They haven't asked for a fix on the 3% versus 4%.
Maybe you're right. Maybe so there have been legislation proposed, maybe not by the CCC, that has sought to provide greater limits and on the amount of donations and on the impact fees. Is the rolling admissions requirement, that's not in the statute, right? I don't know why can't they do what Salem does, which is look at all 5 of these and say, okay, I've got no economic empowerment proposal out of the 5. I've got 4% requirements here. But can't they do that? Or is their regulations, they may be like handicapping what they can do, but I just don't understand where its basis is. I'm not sure either. I think there was some legislative history that spoke to, a different method of not going with rolling, but then that was not adopted in the revision of the referendum. But it's my understanding that that's where they are with this.
The referendum's language includes rolling decision making or not?
I don't believe so. But I think there was some legislative history about the fix to the referendum that would have prescribed a particular process for the CCC, and that was ultimately not adopted.
But you don't disagree that allowing municipalities to add on additional fees and donations and whatnot can lead to trouble, right?
Yeah, and Chief Justice Spud, yes, I agree, it can lead to trouble. And I think that is why the city put it in writing. And we had initially negotiated an agreement under these terms with the existing medical provider. And we used that as the template for what we put out there for the HCA application process for the remainder. Keep in mind that ATG, our original medical dispensary that was within the city, we were already a party to a community benefits agreement with ATG prior to them becoming a retailer. And we just moved those, when we reached a combined agreement, we included community benefits inside the HCA along with the community impact term.
So your position, counsel, is that so long as the town is transparent about these extra fees for whatever purpose and whatever they're called, they really have an unlimited ability to charge these fees and then to award the HCA to those who are able to meet this economic bump for the city.
We indicated, and I believe our process bears this out, that we only required the minimum. So there was not going to be a bidding war about who was going to get an HCA. We had our minimum terms that we had already agreed to with ATG, and we were going to just carry those through. As far as unlimitedness, I believe, it would come down to the point where a particular retailer would say, no, thanks. I think I'll go to Danvers. I think I'll go to
So it's just a marketplace correcting itself. I'm not willing to, make a donation of $100,000 this year. And so I'm not going to apply for Salem, but there's nothing to that 3% cap in the statute, so long as whatever you call it is something other than the community impact fee.
I believe the city is entitled to negotiate community benefits in the form of donations. And that's, the city has that power within the general laws side by side with the responsibilities and powers of local control under Chapter 94G.
Ms. Caldwell, when the host community agreements are up at the CCC for determination concerning a license, does the statute or regulations provide an opportunity for the municipality to be heard as it relates to certain details, like how many dispensaries should there really be on Highland Avenue?
No. We don't have any role at the CCC other than certifying that we've entered into an HCA, and then a later, right after it's almost ready to go, we certify that they are in compliance with all local ordinances and bylaws, meaning that perhaps in some communities where zoning comes after HCA, then we would, the city or town would sign off that they're in compliance with zoning, and even local licensing. Salem had this HCA process, but many cities and towns have almost full-blown local licensing schemes that the CCC has also countenanced.
Does the CCC get all of the materials from your process when a license goes before them? Do they see the terms and conditions you established to play? And do they get your process, or do they just get sort of selective parts of it?
They don't ask us for any of that. I mean, our process has been online and has been made publicly available, since the beginning. So we have a published process. And that's the other thing to keep in mind here is that, there are cities and towns with basically no published process, and that companies individually approach the mayor or the board of select persons and ask for an HCA, and it's either given or it's not. And I think that's the area where the most concern, could lie. Our process was transparent. We were clear about what we wanted, and we held everyone to the same standard. And I think that, all things, a different mayor could have made a different decision, I think, as I pointed out in the brief. But in the end, it's the mayor's discretion as to who to enter into one of these agreements with. It's an entirely discretionary decision. And she didn't abuse that discretion in this case in choosing 4 retailers and rejecting 4 others. And the other thing to keep in mind too is that, should the CCC reject or not issue final licenses, there is an opportunity, the matter isn't over yet. There's an opportunity to come back in here if we end up below our cap. And there's also an opportunity politically for companies like Mederi and others to come in and seek to lift the cap.
Okay, any other questions? Great, thanks so much. We'll
Thank you,
take
Your
our
Honor.
morning break at this time.